Okay, well, moving forward then, we're looking at chapter 3, and what we want to touch on here, basically this new thing that we've talked about in the last chapter, just kind of leading up to this, is what we call pre-petition. Counseling. Okay. So what we have here is you have people. I'm going to just try this over because I goofed it real bad. Sorry. Pre-petition counseling. Okay. So you have people that feel like they're in a bind. They need to go through some form of bankruptcy. They don't know what to do. So basically they have to go through a form of this counseling. Attorney can help line them up with the agency that is approved by the bankruptcy court that gives them this counseling. They go through the counseling. There is a fee for that. They have to pay it. They get a certificate that says they actually went through the counseling, which has to be included with the man, I'm losing it. That goes with it. Says, okay, yeah, they actually went through the form of counseling, and you know, after there is some group of people that do decide that they will go into chapter 13 instead of chapter 7. It's a relatively small percentage. Some people, there's just no way they could ever be involved in a chapter 13 wage earner plan. There are some people, though, that might be able to make it work. But I think if you would line up attorneys that have done bankruptcies for, let's say, 20, 25 years, and you ask them, you know, just how effective is a wage earner plan? How many people actually make all their payments? It would be a handful. It's like hen's teeth. It's what growing up on the farm we used to call hen's teeth. You know, you say, well, does a hen have teeth? No. So it almost never happens, is what we're really trying to tell you, is that wage earner plan almost never works. But people are put in a position where they have to try it. A lot of people go into it. They may try to work their way through it for a period of time. A lot of times tragedy attacks again. They end up having to file another form of Chapter 7, a liquidation, or they convert to Chapter 7. Quite frankly, there are chronic people out there that file bankruptcy many, many, many times. And with those, what you see is they get themselves out. Let's say they can file bankruptcy, let's say every 6.5 years. And then let's say they get to 5 years and they need to file bankruptcy again. But they can't. Well, what a lot of times they'll do is they'll file a Chapter 13 wage earner plan, and they'll kind of slow walk their way through that wage earner plan until they can convert again to a Chapter 7. So this is the kind of thing that you get into. Well, when that original petition gets filed, you know, it's a very large document. The thing we'll have you start out working on is just the petition pages. It's the first couple pages, okay? But the whole document, it can be 130 pages. You know, it can be a really, really long document because it has exhibits, it has legal description of legal property, sometimes these long, lengthy meets and bounds descriptions of real estate take up like a whole page. You have to be attached. There's no way it'll fit in the petition. And so, you know, there's a lot of different things that come up in each different part of a person's life in terms of an estate. All that has to be put on paper. That's what a bankruptcy petition consists of. There's like 22 different subparts to a bankruptcy, and each one of those can be 2 to 5 pages long. So it just depends on each one. Some of them are relatively simple. It's just a really big number on there of debt. It's a nut they cannot crack under any circumstances. And then that income is a lower number. So, you know, if you come out and you try to file a Chapter 7 and your income is significantly higher than your debt, it's not going to work. That's got to be rethought through, and that's where this counseling comes in. It's where you work with your attorney, try to sort out, well, what would be right for me? You know, some people, I talk them completely out of filing bankruptcy. Don't file it. It's not worth it. You don't have enough debt. I get college kids especially that think, well, I'm in a jam, I don't know what to do. Well, you know, most of your college loans, you cannot file bankruptcy on college loans because you owe it to the government. Usually taxes, college loans, child support, things like that, you cannot file bankruptcy on those items, okay? Other things, car loans, stuff like that, you can file, you know, and you can force them into what we call a cram down, which is where they may say, well, you owe me, let's say $20,000 on this $5,000 car. Well, the bankruptcy court could say, well, no, this car's worth $5,000. They're going to pay you $5,000. So that's the kind of stuff that can happen in a bankruptcy, you know, in these kind of situations. Well, order of relief is the next thing. In other words, prerequisite to any kind of an order of bankruptcy relief, which would be the automatic stay, is proof that you went through the pre-petition credit counseling. And that is something that has come up since 2005. It is a requirement now, so people have to go through that, get some kind of help in figuring out, well, is there any way I can take care of this without filing bankruptcy? Quite frankly, in most cases, the answer is no. Okay? The other question that comes up, well, rather than file a 7 or liquidation, would I be better off to file a 13 or wage earner plan? Now, sometimes that does happen. It is pretty rare, but it does happen. And also as saying that, you know, it's important to understand that a person who is seeking bankruptcy relief, you know, cannot be a debtor and cannot continue, in other words, incurring debt. So basically you have to go to an approved creditor counseling agency, which is within 6 months or 180 days prior to the filing of the petition. So you have to be able to prove that you went to an approved credit counseling agency and had counseling within 6 months prior to filing your petition. So you tried, is the point. Debt relief agency is a person including a bankruptcy attorney, bankruptcy petition preparer, or somebody that provides bankruptcy assistance. Now, one of the things you want to be very careful with on this is a federal code section, 11 U.S.C. 101-12A, okay? Now, bankruptcy attorney, clear, you understand that. He's an attorney. He can file bankruptcies. But a bankruptcy petition preparer, I've actually had some paralegals say, well, I want to just be a bankruptcy petition preparer. You want to be very careful on this because bankruptcy slops over into collections, it slops over into property, estate planning, different things like that. And so you have to be very careful because it is a misdemeanor in Indiana to practice law without a license. So you don't want to do that, whatever you do. Okay, always a disclaimer here. We're going through these statutes, always subject to change. And so, you know, you need to do your own research, talk to your own attorney. If you're viewing this and you have other questions, if you're in my class, you need to be viewing this because it's part of our class. Okay. Debt relief agencies are subject to written retainer and disclosure requirements. That's under 11 U.S.C. 527 and 528. What that means is you have to disclose to the bankruptcy court whatever it is that you're paying to a lawyer to handle your bankruptcy. And so that's something that's always been there. That's been there since the first time I can remember ever doing one of these was in the 70s. It's always been there to my knowledge, okay? Bankruptcy assistance, it's goods or services that are provided to a person, including advice, counseling, document preparation, court appearance, or anything like you know, related to that in a bankruptcy proceeding. One of the things you've got to be careful about, if you launch into some of these things, you know, once again, I mean, you don't want to get yourself into trouble trying to do bankruptcies for other people and not really know what you're doing. Usually the best case for most paralegals that I deal with is they go to work for an attorney that handles bankruptcies, because you always have somebody you can lean on that can give you advice about new changes to the law or something that you didn't cover in this class. So you want to be very careful about trying to go out there and practice law, is what I'm saying. And bankruptcy is one of those really kind of touchy areas. Another one is Social Security. You've got to be really careful what you're doing when you're involved in that, because you don't want to like launch out on your own and be freelance paralegal. Indiana does not allow that as much as maybe some other states, like Florida again. I don't know why we keep bringing up Florida, but I guess it's because I'm wearing this shirt. Okay, well, you know, there's a struggle that goes on all the time right now with whether a bankruptcy attorney is a debt relief agency under Section 101. And so different courts have come back different on this, but generally speaking, Minnesota, Florida, and Georgia have all agreed that attorneys practicing in bankruptcy court are not debt relief agencies. So that's something to keep in mind. Voluntary bankruptcy, I talked earlier a little bit about involuntary bankruptcy. This is strictly about voluntary bankruptcy. Voluntary bankruptcy, where the debtor actually initiates the bankruptcy. And that's where I'm saying the person has to go through the counseling prior to filing. In other words, within 6 months after going through the bankruptcy counseling, that's when you file. So it's a question of timing. When's the right time? So you want to get the bankruptcy counseling done right away. And that might be something that the paralegal would work with the attorney to schedule for the client to get them into that counseling, because really that petition's not going to go anywhere if we don't have that certificate that the person completed the counseling. So most of the bankruptcy proceedings that we see are voluntary bankruptcies. Very rare to see an involuntary bankruptcy, and that's where the creditors kind of gang up on another creditor that they think is getting more favorable kind of conditions from the debtor. And once again, I pointed out earlier about priority. Sometimes the debtor takes care of their relatives first when they should be taking care of everybody equally. It's important to know which bankruptcy court that you should file in. Indiana has multiple places, multiple districts where you can file bankruptcy, and you're really supposed to file the bankruptcy in the venue where the debtor resides, or it can be where the debtor's primary business is located. So the question is, should you put it, for example, in Fort Wayne, or should you put it in Indianapolis? Well, if the person, let's say, lives in Marion, but they commute to work in Indianapolis, then there you have a question. Now, ask any attorney, which would you rather file in? Well, I'd file in Indianapolis before I'd ever file in Fort Wayne. But it's one of those situations where, here again, if a certain person is a farmer, they live on a farm, Grant County, Huntington County, somewhere like that, just about going to have to file in Fort Wayne. You don't really have much choice, but you do get a little bit more favorable treatment in Indianapolis than you do in Fort Wayne. Bankruptcy proceedings are initiated by one or more creditors. In an involuntary, case, they seek the entry of an order of relief, and this is what we called, and we talked about earlier, as an involuntary bankruptcy petition. Creditors initiating an involuntary petition are called petitioning creditors. The order for relief, what this can be is some form of an order. It's going to be different for different people. It's going to pertain to what exactly that they're asking for. Sometimes, it's age-old story. Sometimes you get half a loaf and not a whole loaf, but half a loaf is better than none, according to that old saying. And that is really true in bankruptcy, because up till now you've got nothing, but by filing the involuntary bankruptcy, at least you'll get something, or at least in theory that's true. Okay, well, we're moving on then. We're going to move into Chapter 4. This is everything we were going to cover on Chapter 3. When we get into Chapter 4, we're going to be looking again, motion procedures in the bankruptcy court, qualifications to be a debtor in the bankruptcy court, and remaining provisions of the bankruptcy code.